For judgment serial number 1, WPC 11122 of 2017 and batch of matters.
We have issued a direction to the OMC to consider the petitioners for promotion as senior pharmacists. Issued a series of directions.
For judgment item number 2, WPC 38822 of 2021 and 38823 of 2021.
The notices are quashed. The writ petitions allowed.
For judgment item number 3, WPC 1608 of 2022.
Writ petitions allowed.
Hello, I am for the bank. Here the appellant assailing the order of the learned single judge at Annexure 1. But during the pendency, at the time of initial filing of the case, the Honorable Court was pleased to allow interim order of not to, kindly see the first order dated 4/12/2014. After hearing the learned counsel for the applicant, we are of the view that the operative direction contained in
Have
the
you completed the inquiry?
Yes.
Have you completed the inquiry?
Yes, my lord. In the extended period that I have filed an MS case for extension of time, and within that extension period, the inquiry is over.
What is the result?
Result is, my lord, though initially it was found guilty, but subsequently he was partly proved. It was partly proved. But now the petition has expired.
So nothing remains.
No, but I have filed a substitution petition.
No. What has happened at the inquiry? You're not telling us that, sir.
Inquiry, my lord.
What is the punishment that you've given?
First, my lord, kindly see the punishment at annexure. Initial punishment at 45 of the writ appeal and also in the writ application, page 45 out of the first on the punishment.
Sir, you have implemented the order of the single judge. He had asked you to have a de novo inquiry. You have done that.
Yes.
So nothing remains in this writ appeal.
No, my lord. At least, my lord, what remains? He has admitted the charges.
So you have done a fresh inquiry. You have already conducted a fresh inquiry. It's all over. So
over.
why go back? Why go back to that old one now?
No,
you've conducted a fresh inquiry. You've come up with a fresh order.
No, not my lord. Inquiry over, but no order has been passed.
You passed the consequential order, sir. You have implemented order of the single judge.
But in the meantime, the person has expired.
Whatever you have to do, you do, sir. You have to. If the punishment is dismissal, you don't have to pay. If it is less than dismissal, pay the retirement benefits to the LRs.
But I have.
You don't need the court for that.
I have filed a miscase for substitution.
That's all right, sir. We don't have to now postpone, keep this matter pending for all that.
But one humble submission before my lord, that my lord allowed us to complete the inquiry there, and he has also given his reply to the inquiry report. There the matter remains. Now, if my lord directs,
proceed and finish it, sir.
Yes.
It is stated that the inquiry has been completed, and the report is also available with the bank. Since this is virtually in compliance with the order of the learned single judge, the court sees no reason at this stage to interfere.
No,
let the fresh inquiry be taken to its next logical step. Full stop. If, as mentioned by the counsel for the appellant, the respondent employee has expired, then his retirement benefits, if any due as a result of the inquiry, will be paid to his legal representatives in accordance with law. No further directions are called for. The appeal is disposed of.
My lord, one humble submission. My lord allowed us 3 months time.
I'm not saying anything, sir. As expeditiously as possible, you say. All right.
Supplementary list item number 3. Item number 3.
None appears dismissed.
Item number 4.
My lord, item 4. So far as the review is concerned, 165/2014 not pressed.
Review petition, you said dismissed is not pressed. Yes, sir. The others, nobody is appearing. Okay, none appears for the appellant. The appeal is dismissed.
Item number 5.
I am for the respondent, my lord.
All right. None appears for the appellant.
Notice was issued, my lord.
No, but none is appearing for the appellant, sir.
My lord.
So dismissed for non-prosecution.
My lord, because of pending of the case, my lord, my case has not been considered, even though I am continuing last.
Yeah, now the impugned order of the learned single judge should be implemented without delay. All right.
So
that's what it means, sir. Appeal is dismissed means the order is confirmed. Right. Review petition.
Which assignment list?
Which one?
The second review is I have not filed the stranger file, third person file.
So it's nobody appears dismissed, sir. That's
fine.
All right.
Supplementary list item number 6.
Item number 6, I have handed over your lordship's order. In the very impugned order, your lordship have dismissed the writ appeals on merit. Matter being the policy matter of the government. with regard to
In view of the dismissal of writ appeal number 488 of 2017 by the order dated 18 October 2022, these writ appeals are dismissed. All right.
item 7 also, sir.
Sorry, sir. Sir, item number 6, sir. Prashant Kumar Naik, WA 482 by 2017, sir. Sir, advocate konosi karanabasathe hetu aji absent achandi, sir. Setme mu asi eti chedais mu, sir, janini, sir.
Sir, we have already dismissed these matters.
Again, sir. WA 482 2017.
Acha, in 482, you say counsel for the appellant is stated to be in some personal difficulty today. List on 14th December. So you tell him it's 14th December.
Sure.
442.
WA 442.
Same prayer, is it?
Sir, same, sir.
Same, sir.
So both those 442.
4, sir.
There's no 442.
Sir. 44 WA 442 by 2017.
Such number.
Item number 6.
6.
Leading case, the first case.
First case. Acha, both these cases you put it for 13 December. All the rest you can say same order.
14 December रे आसीबा आपण.
Again, sir.
Supplementary list item number 7.
7 also same, man.
Same order.
Supplementary list item number 8.
None appears dismissed.
There are 5 cases.
All dismissed.
Supplementary list item number 9.
None appears dismissed.
Supplementary list item number 10.
None appears dismissed.
Item number 11.
None appears dismissed.
Item number 12.
None appears dismissed.
Item number 13.
Appears dismissed.
Item number 14.
None appears dismissed.
Item number 15.
May I please your lordship? I have challenged the order dated 28/6/2019 passed by the learned single judgment. I have non-application mind that have disposed of the writ, dismissed the writ application on the ground that the petitioner is a old age. According to Annexure 115 mile. Annexure 1 categorically says that the date of birth of the petitioner is 7/5/1974. At the time of discharge, they have at the age of 27. But he has on the ground that he has dismissed on the ground that they old age. And the dismissal order passed that Annexure 2 mile, the categorical. Ignore the order of the discharge manual. I have filed an appeal before the appeal. I have filed an writ application before the lordship, and your lordship directed to file an appeal before the appellate authority. Thereafter, I filed the appellate authority. Thereafter, I come before the lordship. They have rejected on the same ground. Thereafter, on the same ground, they have rejected the learned single judgment.
Yes. What is the ground on which you are challenging, sir?
Challenging the fact that the order of discharge passed by the commandant of police is null and void. That at the age of discharge, he was at the age of 27 years only.
31 years, sir.
Yes, ma'am.
31 years. He was 31 years.
Yes, ma'am. The suspension that has been the order which has been issued in 1978 and 1914. At the age of 14, he was on 31 years.
Yes.
Discharge on the ground of the old age, man. Old age and weakness.
Yes. See, you are a home guard. You were a home guard, correct?
Yes, ma'am.
So what have you to show about your fitness?
Yes, ma'am. Even if as per the Home Guard Act and the rule, as per the Home Guard Act section 8 and the rule 3.
So these are all disputed questions. How do two judges determine whether you are weak or not at the time of your discharge? How can we determine that?
That is annexure 1, my lord. They have categorically said the date of birth is 1974, my lord. Annexure 1, running page 16, my lord.
What does it say?
That is date of birth is 1974. At the time.
No, sir. About weakness, about your physical condition. How can two of us as High Court judges determine what your physical condition was at the time of your discharge? How is it possible?
They have dismissed on the ground of age and weakness, my lord.
Sir, I'm asking you on the question of weakness. How do you expect two judges of the High Court to sit in appeal over your condition, medical condition of weakness at the time of your discharge? How are we supposed to know whether you are weak or not weak?
That is the demand. If a person is weak, my lord, they would send to the medical board, my lord.
Have you got yourself examined by a medical board or contemporaneous to that date? Do you have a medical certificate, sir?
My lord?
Do you have a medical certificate at the time of your discharge to show that you were not weak?
My lord. I'll show you, give me time.
Not I will show, not now, sir. You can't suddenly in 2022 produce a certificate about your state of medical health in 2015.
No. As per the law, that is the duty of it, that they have discharged.
No. If you want to counter, you have to prove your case. Suppose you are saying, sir, they are saying I was weak, I am not weak, you have to prove.
Yes, my lord.
Where is the proof that you were not weak?
That medical certificate I have not. That's the duty of the when the
Services duty. Don't expect somebody else to prove your case. You have come to court. You have to prove your case. All right. That's very basic rule. That is a very basic rule.
Yes, ma'am. My lord.
Where is the medical certificate contemporaneous to the date of your discharge to show that you were not weak?
May I pray before Lordship, my lord, at the review board, the discharge order has been passed. Review board, when the review board is conducted by the commandant of Home Guard, my lord, they have stated that the officer is old and weakness. And that is.
Sir, if you have to counter that, you have to produce another medical certificate to show you are not weak.
No, they have said that I have.
Sir, anyway, I think if you have not understood, then we cannot help you, sir.
No, my time may be permitted. I will give the.
No. Not now, sir. I'm sorry. You should plead it in your petition itself. In your writ petition, you should have pleaded. You should have enclosed the medical certificate. You should have said that the determination by the medical board about my weak was wrong. Please find enclosed as annexure so and so the medical certificate issued around the same time.
Then they have not sent to recheck of medical board, my lord.
All right. Anything else, sir?
At the time of discharge, as per the rule 83, my lord, that opportunity should be given to the as per the Advocate Act Advocate Home Guard Act 1961, 83. That is the opportunity should be given to the opponent. And Rule 10 is categorically said that 1 month notice should be given to the petitioner before discharge. But that have not considered, man. They have not, neither they have issued the notice, 1 month notice, nor they have given opportunity at the time of hearing the appeal, man. Right. Even the statute has provided that may I read, my lord? Rule 83.
Yes.
When Commandant General or the Commandant pass an order of suspended jurisdiction, fining or dismissing any member of Home Guard under subsection 1, he shall record such order with reason thereof and inquiry in writing, and no such order shall be passed by the said Commandant or Commandant General unless the person concerned has been given an opportunity of being heard in his defense. Even though your lordship directed to file an appeal, and I have asked your lordship to file an appeal, but they have, without giving opportunity, they have rejected me.
You see, This is the challenge in the present appeal is to an order dated 20th June 20, passed by the learned single judge, dismissing writ petition civil 2685/2019 filed by the petition appellant, questioning his discharge as home guard by an order dated 30th April 2005, passed by the Commandant General of Home Guards, Odisha Katak. Paragraph. The aforementioned writ petition was the second round of litigation. Full stop. Initially, the appellant had filed writ petition civil number 20775 of 2012, which came to be disposed of by the learned single judge by an order dated 18th December 2012, noticing that the discharge order was an appealable one and permitting the appellant to avail of the said remedy. Paragraph. Pursuant to the aforementioned order of the learned single judge, the commandant the appeal of the considered the appeal and rejected the request of the appellant for re-engagements on the ground of open quotation, old age and weakness, unquote. This order dated 18th March 2013, which purportedly was communicated to the petitioner only on 7th January 2019, was again assailed by him in writ petition civil 2685 of 2019, which has been dismissed in order. Full stop. The learned single judge, noting that the Commandant General had opined that on account of weakness, the appellant is unable to discharge his duties, open quotation, rightly disallowed the appeal filed by him, unquote, full stop. Counsel for the appellant contends that the mandatory procedure under the relevant rules prior to discharging a home guard has not been complied with in the present case. Full stop. He maintains that the appellant was only 30 years at the time of his discharge and could not be therefore said to be of single court's old age. Full stop. As regards the ground of single court's weakness, unquote, he seeks to assail the determination by the medical board. Paragraph. It is seen that the appellant was not able to produce before the learned single judge any contemporaneous medical certificate which could have countered the determination as to the physical condition of the appellant, particularly as regards his single court's physical weakness, unquote, full stop. Considering that the job is that of a home guard, if the appellant wanted to challenge the determination of his medical condition by the medical board, he should have placed on record before the learned single judge some material that could have persuaded the single judge to send him again for a fresh evaluation by an independent medical board. Full stop. However, since the petitioner did not avail that opportunity, the learned single judge deferred to the determination of the appellant's physical condition as determined by the respondent authorities. Full stop. The court is unable to find any error having been committed by the learned single judge in dismissing the appellant's writ petition. There is no ground made out for interference. The appeal is dismissed.
Supplementary list, item number 16.
None appeals dismissed.
Item number 17.
None appeals dismissed.
Item number 18.
None appeals dismissed.
Item number 19.
None appeals dismissed.
Item 20.
None appears dismissed.
Item number 21.
No instruction.
No instructions
Obliged.
dismissed.
Item number 22.
None appears dismissed.
Item number 23.
Please, Lordship. I am appearing for petitioner on behalf of Endure Private Limited from their office. Our counsel is indisposed due to some personal difficulties.
All right, counsel for the petitioner is stated to be indisposed. 24 January.
Obliged, Lordship.
Item number 24.
Pass over.
And for the opposite party.
Item number 25.
May I please, Your Lordship? This is a order challenge under section 74 regarding demand of penalty under section 74 determination of tax, my lord. Only on the ground natural justice has not been followed. My lord, 74, 75 determination of my lord, statute provides at least 3 opportunity to be granted to the my lord, assessee, Your Lordships. And with they have issued a notice on same day hearing and same day for filing of show cause with who is the petition not filed, and after that they have order pass and order identical matter, my lord. I have submitted to judgment recently 2022, my lord, Jharkhand High Court and Madras High Court. Matter quashed and remitted back after giving opportunity of hearing, my lord. And I have
Isn't
so,
this order appealable, sir?
no, my lord, these opportunity of Lordship, kindly see the order 74 statutory, my lord, the rules, Your Lordship. Just
Whatever, sir.
Your Lordship, kindly.
Can you not urge that ground before the appellate?
No, my lord, this otherwise, my lord, here is a difficulty is that, my lord, they have here the order passed under 74, my lord, on the ground of fraud misrepresentation, my lord. And here my case under coming under the 73, my lord. And the my lord, appeal, my lord, in this case, my lord, there is no opportunity. This, Your Lordship, kindly have 74, my lord.
Just answer the question, sir. Is this an appealable order or not?
My lord, this is an appealable order. If the
Can you
following the procedure, my lord, the
All right.
object will.
Suppose, is there a bar in the statute that if an order is passed without following natural justice, it cannot be appealed against? Is there a bar?
No, my lord. Subject to Your
Is
Lordship,
there a prohibition that before the appellate authority, you argue that the order under appeal is in violation of natural justice? Is there a bar?
No, my lord. But
That's-
Your Lordship, only once.
Or is there a bar that you should not cite any judgment of any high court before the appellate authority?
Lord, that's I am not only requesting Your Lordship, kindly 75 for Your Lordship. Your Lordship, 75 for Your Lordship. I have given the copy of the relevant portion of the chapter, my lord, that Your Lordship kind of thing.
Right.
This is similar demand and recovery chapter 15, and this is Your Lordship that specifically provides, my lord,
Right.
and any an opportunities shall be granted, my lord.
Right.
And hearing request to the writing person.
Yeah.
Your Lordship, section 5, Your Lordship. I have given it, my lord. This is a very GST Act or State or GST Act, Your Lordship. And the Your Lordship, the proper officer shall sufficient show cause so the person chargeable with the tax grant time to the said person and adjourn the hearing, my lord. There is a provision of adjourn hearing to be recorded in writing, provided that no such adjournment shall be granted for more than 3 times to a personal person during the proceeding. So minimum 3, my lord, they have, my lord, one day they have issued show cause notice, they have passed an order, my lord. So, my lord, this that is even there is an argument subject to Your Lordship. There is an argument by the same revenue in the 2 high courts, and 2 high courts matter remitted though. So there I object of the so cause notice is frustrated, Your Lordship. So I, my lord, I'll definitely, if the order is passed, I will file appeal. Lord, so the matter may be grant opportunity first hearing. Lord, this statute provides, Your Lordship. I'm not weighing the statute of the Lordship. That is my only submission, Your Lord.
Your Lordship, let me clarify at the outset, at the prima facie on the face of the order, Your Lordship. Your Lordship, so far as the same date, so cause notice as well as the order, my learned friend is wrong. Your Lordship, the so cause notice has been issued on 21st January 2022. Has not appeared, has never appeared, Your Lordship, never requested as per section 75(4), never requested for personal hearing. And for that reason, due to non-appearance.
You already have the counter affidavit in the appeal.
Non-compliance of the so cause notice, Your Lordship, on 20.
So it's like advance intimation to you about what his grounds of defense are.
I am saying that three. There is provision for 3 opportunities being granted, Your Lordship.
All right. You say permitting the petitioner to avail of the statutory remedy of an appeal provided in accordance with law. The present petitions are disposed of as withdrawn.
Lordship,
All right.
Including delay in filing order.
Yeah. If there's any delay in filing the appeal, provided it is filed not later than 14 November 2022, any explanation offered on account of the pendency of the present writ petitions will be considered in accordance with law by the appellate authority.
I'll oblige your lordship.
Two matters, is it? Only one. Only one. Okay.
Oblige.
All right.
Item number 26.
26, may I please, your lordship. Challenge in this case is to the reassessment order, which has been passed without the communication about the acceptance of the returns filed by way of self.
So same question, sir. Is it an appealable order?
Yes, my lord, it is appealable, but anyways, it has been settled by your lordship's order in the case of Ekmax Racing Private Limited, my lord. Firstly, your lordship had decided the issue in the case of Keshav Automobiles with regard to VAT Act. Then, my lord.
Entry tax. Ekmax was entry tax.
Entry tax, my lord.
So there cannot be a reopening unless
reopening. Exactly, my lord.
So this is covered, Mr. Mishra.
It is covered. Here, your lordship may kindly turn to the impugned order that has been passed on 30th November 2017, which has been served on the petitioner on dated 8th January 2018 by the circle office. Your lordship, his endorsement is there, your lordship.
Okay.
He has received the order.
What were you doing all these years?
And in order to file only, he has applied.
What were you doing all these years? Waiting for the judgment to come?
No, my lord, we have received my lord, we have received a copy after the authorities issued notices for recovery. Thereafter, we came to know about this order, and we
when did you come?
April 2022, my lord.
Can't be, sir. 2017 order. How do you know in 22? No, it still becomes a disputed question then. You better prefer appeals, permitting the petitioner to avail the remedy of an appeal in accordance with law. The petition is disposed of. Same thing. If the appeal is filed not later than 14 November, accompanied by an application for continuation of delay, explaining the delay on account of pendency of the present petition, then it will be.
Item number 27.
May I please?
Yes.
In this case, the petitioner is a cooperative bank. He availed the benefit of the promulgation of the Department of Law, that Direct Tax Vivad Se Vishwas Act 2020, where the petitioner disputed amount was settled and it was found to be an excessive payment. So as per the order, the petitioner was liable for a refund. When the petitioner pursued the matter, it was been communicated the matter is in process and due course a refund process will be allowed. In the 2022 May, so the petitioner received an order from the department that there is an refund amount as per Annexure 5, 5A, 5B for 3 periods. There is a refundable amount. But in the meantime, the petitioner came to know from the portal of the income tax that such amount has been adjusted. As per Section 25 of the income tax, they cannot adjust without intimation to the petitioners, without issuing any notice to the petitioner. It has been communicated that the amount has been adjusted. So when the petitioner communicated to the department, only he was issued with the refund order as per 5A, 5B. But till that, they are not issuing any refund.
All right. Who's for the department?
Yes, my lord, I am appealing. Let me take instruction, my lord.
All right. Notice. Mr. Chimanka accepts notice for the opposite parties and seeks time for instructions. Paravis reply be filed to the petition within 4 weeks, rejoined up the next day.
Item number 28.
I pray for the stay because if any adjustment that may be.
It will be notice on stay also. Right.
Obligation.
Item number 28.
Pass over.
Item number 29.
May it please your lordships. The issues involved in this writ application are squarely covered by 2 judgments of this honorable court. My lord, the issue is the faceless assessment center unit cannot, in breach of the provisions, pass an order. Here, the draft assessment order has furnished to the assessee. And as per clause, yes. that has to be done. And secondly, the notice under section 143(2), which is mandatory under section 144(b)(1), that has not been issued. Your Lordship have delivered two judgments, one in Principal Commissioner of Income Tax versus Orissa Mining Corporation. I have given the compilation mailers. And the first one, your Lordship has said that non-compliance of not giving the assessment order to the assessee, that is Srivastava Swami versus Union of India, page 1 of my compilation. And these judgments have been followed by many high courts, including the Gujarat High Court mailers.
Anyway, all right.
That this is
Notice-
mandate.
All right, notice. Where is, who's
My
there?
lord,
Chimanka.
My lord, 143 notice has been issued at page 18 and matter is applicable.
So cause notice you have issued, Mr. Chimanka. You have only issued so cause. Along with it, read that provision. Clause 23.
Seeks time for corrections.
Page 18.
18.
Yes.
143 2 notice on 29/6/2021, date compliance given 14/7/2021. Then 142 1 notice 28/10/2021, not received, letter, then all this letter is given. Sufficient opportunity is given. And order is passed.
You have not given the draft assessment order where the variation has been proposed.
So that's the main thing. So 144B. 144B has not been.
Read that provision, Mr. Chimanka.
Anyway, you see, one of the contentions raised by learned counsel for the petition, Mr. Rai, learned counsel for the petitioner, is that the mandatory requirement of a draft order under section 144 capital B of the Income Tax Act 1961 has not been complied with in the present case. You say notice, Mr. Chimanka accepts notice, reply, paravis reply be filed within 4 weeks, rejoined up for the next date. List on second February. Till the next date, no coercive action shall be taken.
Chimanka is Pitamo Bhisma.
Item number 30.
30, my lord, demand issued on audit objection. Similar order, my lord.
Same order. All right. Same order. I think same dates, November. Yeah, same dates. All right.
Item 31.
May I please, Your Lordship? Your Lordship, this is a matter of shortfall MPQ of the year 2021-22, Your Lordship, which has been clarified by the state government itself that the shortfall MPQ should be carried out to the next year, Your Lordship.
That is already done, I think.
Yes, Your Lordship.
That is already. This repetition has become infructuous because we have already carried forward for the next year.
All right. The counsel of the petitions have been rendered infructuous and they disposed of as such.
32.
Your Lordship, this is a matter.
Sorry.
No, this is not saying, Your Lordship. This is regarding the shifting of our IMFL offshore, which was not considered by the collector, Your Lordship, wherein they have issued an MPQ, shortfall MPQ, where was the whole year we haven't operated the shop. There was a representation that we wanted to shift the shop. We have represented the collector, Your Lordship.
It's very similar to yesterday, Mr. GM Ratha's matter.
Yes.
Similar to that. You want to take instructions?
Yes, I will.
Notice Mr. Mahanti accepts next time for instructions.
Obliged, Your Lordship.
List on 8th December. Sir. All right.
Item 33.
Item 33 month passed over.
2012 matter, sir. All right, pass over.
Item number 34.
Yes, my lord. This is review petition. That
No grounds made out for review. Dismissed. All right.
Item number 35.
None appeals dismissed.
Item number 30.
None appeals dismissed.
Item number 37.
None appeals dismissed.
Item number 38.
None appeals dismissed.
Item number 39.
That's item 39. This is a review petition. Is the single judge, my lords, on the first date, without, my lords, giving us an opportunity to file 45 days, my lords.
68 days. But anyway, this is a 2012 matter, sir.
Yes, my lord. Just 1 point, my lords. The single judge has directed us to pay the respondents the minimum wage.
In last 10 years, you've not done that.
Yes, ma'am.
That itself the ground.
I should fairly submit that one of the grounds that there are 2 other writ petitions pending. I couldn't find the orders uploaded, so that's why. So
you can confine it to the facts of the case.
Please.
You say no grounds made out for review. Nevertheless, it's clarified that the impugned order of the learned single judge will not constitute precedent. All right.
Great. Item number 40.
None appeals dismissed.
Item number 41.
Lords, it's more of a clarification than a review petition, my lords. In item 41.
All right. We say no grounds made out for review. Dismissed. All right.
Item 42.
None appeals dismissed.
Item number 43.
None appeals dismissed.
Item number 44.
None appeals dismissed.
Item number 45.
May it please, my lords. Whereas I appear on behalf of Mr. Shashwat Kumar Acharya in this matter, your lordships, I seek adjournment on the ground of health. Your lordships, he is.
All right.
If you want.
What's the delay here? First matter, there's some delay.
The case has been admitted, my lord.
Oh, I see.
47.
That MC 216 of 2017, you see applications allowed. And then all the dispensing with allowed. And then you say Mr. Acharya is stated to be unwell today. Learned counsel for the applicant is stated to be unwell today.
Sir, IT.
3 cases.
ITA.
That's all. 20th March.
Obliged, your lordship.
Well, I am appearing in all the 3 cases.
All right, sir.
Item number 46.
None appeals dismissed.
Item number 47.
My lord, item number 47, I'm on VC, my lord. My lord, this is a matter which is to be tagged along with that RERA matter, which is
5th December.
My lord. That is posted in
5th December. List along with
WPC 18799 of 2021.
On 5th December. All right.
Obliged.
Item number 48.
Lord, in item number 48, as per noting, it has been written that steps to implement the petitioners in WPC number 13,241 of 2022.
My lord, that is a different matter, but so the audit petition, that is WPC 13241 of 2022, your lordship has fixed it today for final hearing, and your lordship has already vacated the interim order, and last date I prayed your lordship to take up the final hearing.
Lord, may I make a small submission if your lordship don't mind? Most of the people have gone and we have given them adequate compensation also. But a handful of people are not leaving, although their quarter compensation, everything is ready because the writ petition is pending. So that work in that summary is stalled for a handful of people now.
So we'll take it up with the rest of the matters then?
Lordship, please.
Take it up with the final hearing matters.
Lordship.
End of the board.
End of the board. Item number 49.
Well, that's item 49. This is a PIL. The last occasion, this pertains to a repair work on a road. And that's today, my lords, I have given a pen drive with the
report for the petitioner. Pass over.
Item number 50.
Pass over.
Item 51.
Representation is there. End of Annexed 3 series.
I know, but let somebody appear for the petition. Pass over. Pass over.
Item 52.
Again, pass over.
Orders item number 53.
May I please, Your Lordships?
Yes.
Your Lordships, in this matter, already it is covered by this Your Lordships. I have supplied the judgment passed in OJC number 7605 of 1995. Judgment dated. I have already supplied a copy, Your Lordships.
Yes, yes.
Judgment dated 6/2/2019.
Right. Yes, Mr. Mishra, you there?
Your Lordship, let me examine the issue, Your Lordship, some other day, Your Lordship. Let my learning friend to
Already same in the last occasion, Your Lordship, the order is also in my read, and previous order of this honorable court is also reflecting that order. Regional authority was supposed to pass the order in the light of that, but he has not taken note of that judgment, only confirmed the order. Your Lordship, Annexer 8, page 77, Your Lordship.
No, how Your Lordship, that order, this honorable court has set aside the matter to the revisional authority, has directed the petitioner to file the revisional authority, and the revisional authority will dispose of the matter as per that judgment, Your Lordship. And now, Your Lordship, the revision order is to be examined, Your Lordship. So
this revision order is challenged in, Your Lordship, in that OJC number 7605, revisional order was in challenge. But in the first writ petition, Your Lordships, I have challenged the assessment order passed under section 10A of CST Act, Your Lordships. That is why this honorable court directed me, because the judgment is based on the revisional order. So I have the alternate remedy to approach the revisional authority. That is why I have approached the revisional authority. But who has to dispose of the matter in the light of this OJC number 7605. But without taking note of this judgment, without spelling a word on that judgment, simply he has confirmed the order. So that is why my grievance before Your Lordship, that if this judgment is not supporting my case, let my learned friend say that.
Yes, see, Your Lordship, may admit the matter, I will file counter, Your Lordship. Because Your Lordship, at page 79, come to page 79.
Only?
Initially, the notice, against the notice of the revision, the petitioner challenged and come to this honorable court in WPC number 5465/2016. Your Lordship.
Anyway, the impugned order is Annexure 9.
Your Lordship.
Yes.
Annexure 9.
Yes. Now this is the revisional order. So he has nothing to say that it is not admissible or anything, because in that OJC number 7605, revisional order was challenged. And that was the point for which I was given an opportunity to.
Let me take next week, Your Lordship.
All right, notice, Mr. Mishra accepts notice. Learned Ms. Roy Chowdhury, learned counsel, the petitioner, states that the petition is covered in her favor. In favor of the petitioner by the judgment dated 6 February 2019 of this court in OJC number 7605/95 bracket Messrs. Hirakud Power Company Limited versus Commissioner of Commercial Taxes, Odisha, which according to her was not considered by the revisional authority in the impugned order dated 27 January 2020. Reliance is also placed on the judgment of the Supreme Court dated 10th September 2010 in civil appeal numbers 2344-47 of 2004, bracket Commissioner of Sales, Messrs. Sanjeev Fabrics. Mr. Mishra, learned counsel for the department, seeks time for instructions. At his request, list on February.
I don't know, 54.
Maybe pardon me, Lords, my learned friend is there. I have to address your Lordships on VC, my Lords.
No problem, no problem.
So, from item number 54 to 57, my Lords.
Yes.
Your Lord, these similar matters are being listed before your Lordship's court on 11th of November. This relates to interest on entry tax amount, my lords. After the Supreme Court, Honorable Supreme Court's judgment, my lords.
All right.
So I was only humbly praying that in course of the day, my lords, I'd cured the defects. That is, only copies have to be served on my learned friend, Mr. Mishra. I call all these 4 matters, my lord, 54 to 57 on 11th of November, my lords.
All right. Mr. Mishra said he has received copies of the paper books. These 4 petitions be listed on 11th November.
11th of November, my lords.
11th November 2022. All right.
So let's see, let my
Sorry, my lords, again, my lords, I apologize for addressing your lordships on BC, my lords.
No, please.
Let him serve the copies, your lordship.
No, I'll serve it on course of the day. In course of
All right. I didn't say Mr. Karas says that he will serve copies of the paper books on Mr. Mishra, learned counsel to this department during the course of the day.
54 to 57.
Right.
Item number 58.
Greatly obliged.
May I please, your lordship? Your lordships, in this matter, the impugned order is annexure 5, your lordships, where Learned Commissioner has issued that.
Item number 58, 59, 60. My learned friend has not given copy to me, your lordship.
It is
58, 59, 60. 3 matters. My learned friend is appearing. In these 3 matters, copies have not been served to me.
All right. What is the point involved, Ms. Rajchandri?
Yes, your lordships, kindly have a glance at page 8. Sorry, your lordship, page 7. I'm sorry, page 7. Page 7, para 8. So during the pendency of appeal, Learned Commissioner has passed an order under so motor revision and enhanced the amount, your lordships, without
calling the dealer for personal hearing.
Yes. Appeal is pending.
You should have served a copy, Mr. Mishra, then you could have disposed
already
of.
served. That is why noting is not there. Also. Already I have served.
I'm
because
sorry.
now, because he is not having the copy, so definitely I will serve a copy.
All right, notice, Mr. Copies of the petition be. Mr. accepts notice. Copies of the petition be served on him forthwith.
GST department is also party. Central GST is also party.
No,
All right.
in this matter, only state.
All right.
You
say
only
since
my
the
limit.
point involved is short, to enable Mr. Mishra to seek instructions, list on 21st December.
58, 59, and 60.
Yeah.
I don't know, 61.
59 lordships that may be disposed of because that is covered by that Harismaji case lordships. 59. GST reimbursement matter lordships. 59.
Which case? You'll have to give us a copy of the judgment.
Now Agarwal. That 6/7/6/2021 lordships. Harismaji GST reimbursement judgment. That was dismissed.
All right. The present petition is dismissed in view of the judgment.
Harismaji.
Harish Chandra Maji versus State of Orissa.
7/6/2021 order.
Judgment in 7/6/2021. All right.
60. Item 60.
60/61 is different, and I will apply the copy.
All right.
60, I will supply the copy.
60 and 61, you say notice, he accepts notice. Copies of the petition be supplied today itself.
61 is not my matter.
60. All right. 60. List on 4th January.
Item number 61.
Pass over.
Item number 62.
61, I am appearing, my lord.
All right, sir.
Item number 63. 63, my lord.
Pass over. Pass.
Item number 64.
May I please, lordships?
Yes.
Here I have challenged the first appeal order, but entire tax amount I have already paid after the appeal order, lordships. So my limited grievances, they have not taken in account of the TDS deducted from my bill, Your Lordship.
Your Lordship, since it is against first appeal order, tribunal is not there, Your Lordship may admit and Your Lordship may recognize that.
Since there is no second appellate tribunal constituted yet, notice is accepted by Mr. Mishra. Copies be served on him.
Okay.
Notice on the IA as well. Till the next date, no further coercive steps shall be taken against the petitioner.
Your Lordship may record a submission that the entire tax has been paid. Your Lordship.
Since it is submitted that the entire tax amount has already been paid. All right.
Payment challenge is
all right. Just on 27th January.
Item number 65.
Well, I am in Bhesi.
Yes, please.
This is a challenge the appeal order under the GST Act, and due to non-awarded tribunal, the writ is filed before my lord. So here only mismatching of GST 2A and 3B, and here the petitioner has purchased the goods from the seller from Rajasthan by paying the IGST, and after that, the seller, while entering his return, he wrongly put the some other GSTN number. So in this case, that demand is made that I have not deposited, the seller has not deposited the tax. But here he has given the confirmation that my lord kindly have a glance to page 63, annexure 6. Here,
have you already paid? The first appeal you paid 10%.
Already paid 10%. I have also paid the 20% by coming to this court also. That is in annexure. I have also page 92. I have paid the 20% also.
All right. Notice, Mr. accepts notice for.
I have given the order. Similar order has been passed in the Kotak Medical Supplier. That is
correct. I've seen that.
Your Lordship, in some cases, Your Lordship has directed 100% of the tax is to be paid and 20% in some cases 20%. I leave it to Your Lordship.
Yes. All right. Notice is accepted by Mr. Mishra for opposite party.
Your Lordship, in this case, opposite party number 1,
yes,
1, 2, 3, 4. Your Lordship,
5 also.
4, no, Your Lordship.
1, 2, 3, 4 is Mr. Mishra.
1, 2, 3, 4.
Mr. Mishra accepts notice for 1, 2, 3, 4. Mr. Padi for
5 is state.
6, 7.
And 8, 9, 10, that has to be go, and 11 also. 8 is the
5 I'll be.
No. 8 and 9 will be by whom?
By
Your Lordship, 8 and 10 is to notice is to go. It is out of state.
Notice to 8 to 11.
8 to 11.
Right.
To speed post.
Returnable on the next date. You see, informs the court that the petitioner had already paid 10% of the tax amount at the first stage of appeal and 20% for the amount has been paid. 20% of the remaining amount of tax has also been paid. Full stop. In that view of the matter, it is directed that till the next date, no coercive steps shall be taken against the petitioner. Then next, you say list on 2nd February 2023, along with writ petition civil 39671 of 2021.
But in this case, attachment is also there. But today I got the instruction they have leave the attachment. So
all right.
I don't know.
May please your lordship. I am appearing in this case, my lord. This is a taxation matter, my lord. Matter relates to GST, my lord. I have filed this writ application against the impugned first appeal order, my lord.
All right. Since there is no tribunal for the dealing with the second appeals, notice is issued, accepted by Mr. Mishra. Mr. Mishra accepts notice on behalf of
1, 2, 3.
1, 2, 3.
My lord.
You say, what have we paid, sir?
10%, my lord.
The counsel to petitioner states that he already paid 10% of the tax amount, subject to the petitioner paying a further 20% of the tax amount.
20%, my lord.
That's a standard thing we're doing, sir. Subject within 4 weeks, no coercive steps shall be taken against the petitioner. List on 2nd February, along with same. All right.
Item 67.
None appears dismissed.
Item number 68.
None appears dismissed.
Item number 69.
None appears dismissed.
Item number 70.
My lord, on behalf of Mr. P.K. Nayak, this matter is infructuous.
Counsel, the petitioner states that the petition is infructuous. It is disposed of as such.
Item number 71.
Challenging order passed by the government. Lordship sees, my lord, impugned order at page 16. Lord, consequently, the demand. One thing just I am to tell you, Lordship, Lord, if the Lordship sees annexure 1, page 18, man. Lord, the government in the impugned order has said that in the suspicion of holding a spurious liquor, they sealed the shop for a particular period. Now, those samples were taken, found to be fit for human consumption, nothing spurious liquor was found. They reopened it. Period for which, that is 3rd of October 2019 till 15th of January 2020. This period, since they themselves sealed the shop, I am saying that I am not liable to pay because section 29 says that when I am selling liquor for sale, I am liable to pay duty or license fee, whatever it is. Now you sealed the shop for this period on account of your own suspicion and ultimately found that my liquors are all genuine. There is nothing spurious in the liquor. So they recalled it and they reopened it. For that period, I am seeking exemption that please exempt me from duty. Now,
let me take instructions.
Yes.
Notice Mr. Monte accepts notice for opposite parties and seeks time for instructions. List on 16th February.
15th February.
16.
Can it be little earlier?
No, it's all right. It's all right. Yes.
In fact, my interim prayer is there. The demand. The demand they have issued for a huge amount of 1,49,84,454. But this demand, besides that period, also there are other certificated amount that they have also included here. So what I'm trying to request your Lordship, let them recompute the demand. Against me, I'll pay that.
That is only because the secretary has decided the matter against him. If that is set aside, then the demand will be altered or varied.
Also.
But so far as
genuinely
the current demand is concerned, if he seeks for any stay, if he wants to get a stay order, then he has to deposit certain amount. Then only...
I'm not asking a stay. I'm asking just recompute it, whatever beside this period.
No, notice will go on the stay application.
Notice.
All right.
Item number 72.
Notice, he accepts notice both on the main petition.
Item number 72.
73, no?
72 is called.
72. I'm so sorry.
Pass over. All right. 73.
Item 73.
My lord, in item number 73, I'm in VC, my lord. My lord, petitioner grievance in this case is MGQ for the year 21-22 has not been proportionally waived or refixed in view of closure of excise shop due to COVID crisis on government notification. My lord, distributed to the petitioner. My lord, here petitioner had the new license in respect of IMFL op shop in the district of Baleswar and has been
granted. We'll issue notice. Okay. Notice, Mr. Monte accepts notice.
But father is in court. Why son is inside chamber? I don't understand. He should come to court. Your Lordship may not issue notice. May call him tomorrow. He will come and argue the matter. Then notice will be issued.
Might be having some personal reasons.
No.
No, you cannot say like for your son.
All right. Reply we filed within 4 weeks. Rejoinder for the next date. Same date we can.
Same date, my lord.
Yeah, same date.
Yes.
16th February. All right.
Item 74.
Please, your Lordship. Here is a matter for cancellation of wines of my lord. It is annexure 4 and the already cancellation letter has issued by the Under Secretary of Government. But annexure 5, my lord, I filed a representation to cancellation the wines of my lord. Annexure 5, page 18, my lord.
No. Isn't there an appeal or something?
Yes.
This must be an appeal.
How representation will do? My lord, you have to challenge it in accordance with the law.
Advise them correctly, sir. My lord, counsel, the petitioner seeks leave to withdraw the present petition with liberty to file the avail the statutory remedy that is available to the petitioner in accordance with law.
Simple way, I have filed a recommendation.
No.
There's a format, there's an appeal, you have to file that.
My place is one liquor shop is already closed because of a spurious.
Whatever the grounds, sir, just avail.
Sorry, my lord. So that the villagers comes to the place to the another same person has another spurious litter. So that I simple pay the answer fight to my reparation is it is wine shop for 1 year, my lord. For 2020 to 2023 March, only 4 months, my lord.
So don't waste time, sir. Do it immediately. All right.
This post office withdraw with particular excise law.
But we are the villagers, my lord. We are
whatever, sir.
We are
law is also applicable to villagers.
All right.
Item number 75.
Dispose of, my lord. Based on this.
My lord, here I'm seeking a review of your lordship's order. My basically 2 grounds are there.
2012.
Yes, my lord, there is an interim order. Your lordship had issued notice. There is order. My lord, review on the ground. Your lordship may see the prayer in the writ petition. I was not made a party. The prayer is for demarcation of a leasehold land, and your lordship passed an order that your lordship will see. My lord's order may kindly be seen. My lord directed that the demarcation of the northern portion of the plot allotted in favor of the petitioner trust. Northern portion I am residing. My lord, I was not made a party in the writ, and there is a civil suit pending regarding the lease. My lord, my entire grievance before your lordship is let them demarcate, but involving me, because I am the person who is to be ultimately affected in the demarcation.
My lord, as far as my knowledge goes, once a demarcation case is registered, the boundary owners or any affected parties will be noticed. Any affected, no, read any boundary owners and any affected party will be. If you are a person who is in possession of the northern, then definitely
that only, my lord. I want that only.
So we'll record his clarification.
Yes, your lord.
All right. Mr. D.K. Manthi, learned additional government advocate, states that although the review petitioner may not have been made a party to the writ petition, no further proceedings of demarcation pursuant to the order of the court will take place without notice.
My lord, I do not know whether in the meanwhile.
No, there is no. There was an interim order.
Yeah, without notice to the present review petitioner. In view of the above statement, the court disposes of the review petition, vacating the passed on 3rd March 2012.
One more prayer, my lord, subject to your lordships. There is a civil suit that may be taken into consideration. That is a civil suit between interested parties.
Orders passed in that. So point that out.
Your lordship may only record that. Raise that point of civil suit. That much before the authorities.
We don't prevent you. If you raise it, they will consider it.
Any point may be raised. Your lordship may just record it. I'm not saying to record the civil suit. I will raise my objection to the.
Even if you did not say it, will it prevent you from raising it?
No, there are certain things bottlenecks. That's the reason I'm insisting, man.
Better
or else I would not have insisted, man.
No, it's all right. Right.
Urgent copy of your lordship.
Urgent copy. All right.
Item number 76.
Item 76, your lordship. This review petition has been admitted and as an interim measure dated 19/2/2013. Your lordship, this honorable court had directed not to take any action on the petitioner. Until now, your lordship, opposite party number 1, 2, and 3 have not filed their counter affidavit to this state.
What's the ground of review?
Your lordship, this ground of review has been taken. If I can take your lordship to para number 6, your lordship. The assessment, the Honorable Court, while appreciating the contentions relied in the writ petition, the materials in Annexure 8 series was notices by 67 could not be considered. 8 series are said to have been issued by the opposite party number 3 in VAT 308 under 51 rule of VAT rules. On a perusal of the said notice, the initiation of the proceeding itself is without sanction of law, as there is no mention of period in the para 3 of the notice which is required for the purpose of assessment. And this is again non-application of mine by the opposite number, party number 3. Therefore, the entire order of assessment is without any supportable material, suffers from non-consideration of relevant material.
No, which is the order under review? This is 36/2012.
Yes, your lordships. Yes, your lordship. It has been attached with this review petition. Your Honor. It is in WPC 9203/2012. This has been attached with review petition also.
But how is this? This is a ground for further appeal against the order. It's not a ground for review.
Your Lordship, if I can show you the petition of my review, saying that lot of grounds have not been considered by this Honorable Court. So on that basis, the review petition was also accepted in 2013, and accordingly, this Honorable Court had directed to deposit 25 crores, which to effect I have also deposited. I have filed an affidavit to that effect also.
Who's for the department? All right, who's for the department? It has to be Mr. Mishra. Where is he? Mr. Sunil Mishra?
Your Lordship.
Are you aware of this petition, sir?
No, Your Lordship.
Please serve a copy, Mr. Mahapatra.
I will.
All right. Counsel to the petition undertakes to serve a copy of the review petition, Mr. Sunil Mishra, standing counsel of the department, during the course of the day. Interim order to continue list on 9 January.
Item number 77.
None appears dismissed.
Item number 78.
None appears dismissed.
Item number 79.
None appears dismissed. Mr. Curry, you managed to reach the court.
Lord, I had gone for an emergency purpose.
Oh,
I just held up on the way, my lord.
All right.
Sorry.
79.
79, tell us. Where is your lawyer?
No, sir.
Come to the mic, sir. Just come to the mic. You're Sri Ram Chandra Patnaik.
Yes, sir. I am the petitioner of the present writ appeal.
Yes. Where is your lawyer, or you are arguing in person?
Not available.
All right. Who's your lawyer?
Excuse me. Tilochan Nanda.
I don't know, his name is not here.
Not here.
Trilochan Nanda.
Yes, sir.
But his name is not there in the cause list. You gave him a wakalatnama.
Pardon?
Have you engaged him by... You have changed. Your earlier lawyer was Kunja Sundar Das. Then what happened?
But at the present petition, Mr. Trilochan Nanda is engaged to plead the case. And is not available here.
You adjournment? Are you asking for an adjournment?
Yes,
Yes, he is. It is stated that Mr. Trilochan Nanda is now appearing for the appellant, who is present in person. Full stop. He says when Mr. Nanda has some difficulty today and accordingly seeks an adjournment. List on 16th January.
16th January.
So much of PIL. You see the wakalatnama of Mr. Nanda. All right. No. And his name be reflected in the cause list. Right.
Item number 80.
None appears dismissed. There's some amicus. Amicus is there. Correct.
Excuse me, sir. I want to say redress my grievances.
You have a lawyer, right?
Sir?
Case has been adjourned. You can come at the next stage.
Okay. Thank you.
Item 18.
You have to take some instructions, Mr. Monti.
Yes, my lord. The GA department. That is the last order till 27th July. So give me last chance.
Mr. Monti seeks some more time for instructions. List on 9th February.
Item number 81.
Honorable Court, I am Praful Samantara, one of the petitions of this PIL.
Yes.
Your Honorable Judges, I may appeal that because of our advocate could not come because of Bar Association's restrictions. And I would...
There are no restrictions, sir. Please look at the camera and see how many lawyers are there in the courtroom. All right. You want an adjournment?
Sir, actually...
yes, my appeal is also to her adjustment as well as also to extend that to the interim stay order till the date.
So what has happened here, the environmental clearance, all these statutory provisions are followed.
Right.
So they have filed this application that they have been deprived to participate.
Right.
And your lordship has passed the EC not granted, then it will not be granted.
Correct.
Because the EC was not there. In the meantime, state government has already cancelled my lease on the basis of lapse.
Oh.
Saying that your EC is not there and you could not obtain the EC. Okay. The interim order, we could not get the EC and everything. If your lordship looks at the ATM's order, the affidavit, they have followed all the requirements as per the Pollution Control Board regulation and everything. But there is no lapses and nothing is there. But here the question is, unless the EC is granted, I cannot get my lease revived.
But Your Honorable Court, judges, we have challenged the validity of this public hearing. This was illegal and also force was used not to allow the thousands of people.
No, but where is Mr. Jena who is appearing on your behalf?
She could not come because she could not come because I have to come to appeal to you at least to urgent this case and they will again appear in the next hearing.
Mr. Prafula Samantara.
The other writ which I have challenged, today it was there. Honorable Judge said, unless you get that clear, that EC part, we are not going to pass any order.
That can be clarified. Your lordship can clarify that.
No, your lordship can take it tomorrow, day after, any day. The ADM affidavit is clear.
We have filed the affidavit that all procedures have been followed and legally and everything is there. All notices, all.
But we have challenged the validity of this public hearing. And unless public hearing is again held, people cannot do their justice. Only
2-3 persons were they have filed writ application. Entire village has participated.
I think there is no reason to our
there on behalf of one of the petitioners. And I have a right to go to the court of law. Because there is a judgment in Delhi High Court that Vedanta versus Praful Samantara, that I can go, any person of India, citizen can go anywhere to protest or to allegate or to raise the question or to raise the voices in the court of law or in the public.
Please ask Mr. Jena to remain present on the next date.
Yes, I definitely.
Mr. Prafula Samantara, petition number 5 appears virtually and states that Mr. P.K. Jena, learned counsel, appearing on behalf of the petitioners, is in some difficulty today.
So the other date is fixed to next week. So before that, if your lordship fixes, it's better.
So the earliest date can be 11th November. No, 11th is Friday. Sorry. 9th November. We'll have it on 9th. No, I'm sorry, 8th November.
Right.
So 8th is a holiday. Sorry. 10th is what? Yeah, 10th. Okay, 10th November.
10th November. Right.
10th November. All right.
Supplementary list for admission, item 82.
82 minutes, I am for the opposite party. I am appearing for OMC, Orissa Mining Corporation.
Adjournment been given on behalf of Mr. Satpathy.
What is the reason, sir?
He is out of Cuttack.
Mr. Satpathy stated to be in some difficulty today. (9th February).
And a copy of the memorandum of appeal may kindly be served upon me.
I see. Copy the memorandum of appeal be served on Mr. Rai, and counsel appearing for the respondent. All right.
Obliged. Item number 83.
So item number 83, I'm filing rejoinder today, Millers.
All right.
I will serve a copy of the rejoinder to my learned friends.
All right. The senior counsel to the petitioner states the rejoinders be filed during the course of the day. List on 20th February.
Interim order to continue.
Both the cases, my lord.
All right.
Item number 84.
May it please, Millers. Millers, I appear on in item number 84 and 85. Your Lordships, I have filed a withdrawal memo. So both the cases may be withdrawn as per the terms.
Yeah.
And the petitioner will be given the liberty.
Liberty is granted to the petitioner to withdraw petitioner is permitted to withdraw the present petition with liberty to approach the appropriate forum as and when necessary. All right.
Highly obliged, Your Lordship.
And I am appearing.
All right.
I am appearing.
85.
Same.
Item number 86.
So 86, not I pray for 10 days time to file rejoinder, Millers.
All right. Rejoinder to be filed before the next day.
Interim order to continue.
Interim order to continue. List on 21st February.
Item number 87.
My lords, item 87, I need some time to file rejoinder.
All right. Rejoinder to be filed before the next date.
I'm for the opposite party, Your Lordship.
List on 21st February. All right.
I'm for the opposite party, Your Lordship.
All right.
Item number 88.
Please, Your Lordship, I am appearing for this 88, and it is related to custom matters. And Your Lordship, we are challenging this later dated 19th September 2019, as well as the 5th August 2021, issued by the Customs Department, where they are demanding the differential duty of custom without following the due process of law, where the law mandated them to pass speaking order following the principle of natural justice. Now, Lordship, the facts of this case is this.
No, 1 minute, Mr. Moth. I just want to make sure the Customs Department counsel is here.
Yes, Mr. Radheshyam Chimka.
Yes, I am appearing.
All right.
Yeah. So, Lordship, the case is this, that ultimately whenever any vessels come from outside India or foreign going vessel, and they want to ply in India, then they have to convert their vessel from foreign going to coastal run vessel.
Right.
Into the coastal run vessel, whatever the bunkers and stores lying in the vessel, they require to declare, and whatever the estimated quantity, based on that, they have to pay the duty. At that time, they assess the bill of entry provisionally. And when the vessel is required to sail out of India, then again the vessel will be converted from coastal run to foreign run vessel, and the bill of entry would be finalized. In the present case, there are total 36 bill of entry which are which were filed from time to time. And in all these cases, without basis of natural justice, as well as passing any speaking order which is mandated under the provision of the Customs Act, they assessed the finally and demanded the differential duty. May I request to see the one specimen copy of that annex bill of entry which has been finalized on page number 45 of the petition.
Yes.
Yes. And page 45 just subject reassessment of bill of entry number so and so for vessel numbers, vessel name and date. Please refer to the provisionally assessed bill of entry number so and so for vessel date 11th November 2016. In this regard, this is to inform you that bill of entry number 475 dated 25th November has been assessed by the undersigned on the basis of the reversal documents received from the Customs Department, the Damandar port, where the vessel was reverted on 5th February 2016. The duty of calculation sheet shows there was short payment of rupees so and so in respect of excess bunkers or stores consumed during the coastal voyage of the vessel. You are therefore requested to pay the differential duty under section 18.2 along with the applicable interest as per the provision of section 18.3. Now, interpretation has been shown on page number 46 and 47. Just they said what is the fuel oil, what is the diesel oil, and what is the lube oil, and that amount has been demanded. Now, if you see all of this is that they consider as a finally assessed bill of entry without any specifying reason on what basis they assess the finally. Two, without following the due process where they have to give the hearing. And if you also see the provision how the bill of entry is required to be assessed, may I request to see the that regulation which has been issued under the provision of Custom Act, which has been annexed with the petition, that is on page number 40. Your Lordship.
Yes.
In 40, just may I request to Your Lordship see return the page 42 and rule regulation 6.
Yes.
It provides that from the one, Your Lordship, the provisional assessment shall be finalized as per the provision of Section 18 of the Customs Act, because this regulation has been issued under Section 18. Now, provided that Your Lordship, proviso is not important, so may be allowed to skip, and as well as subsection 2 also. Now 3, where the final assessment is contrary to the provisional assessment, the proper official shall pass a speaking order following the principle of natural justice.
So here no hearing was given to you.
No hearing and no speaking order. 3, 4.
Yeah, one minute, Mr. Chimanka.
Yes, it is an appellate order. It challenge the assessment order. It is challenge the assessment order passed by the defendant, who is the quasi-judicial authority. It's page 13 my counter affidavit. On the
No. Apart from the fact that you say there's an appealable order, do you have any answer to this not giving a hearing?
Yes, it is.
What?
Then.
No. What is the answer to the point that the mandatory requirement of prior hearing was not followed and no reasoned orders passed?
Yes, it is true, sir.
No, which means will it go? It has to go back to the authority then.
It may go to the authority.
I would like to add one more point, Your Lordship. It should go back, but there is a decision of the Honorable Bombay High Court or other, where they say that even speaking order is not passed, it is not considered the appealable order. Appealable order would be considered once the speaking order is passed.
All right.
So it is not an appealable order.
Anyway, on that ground also it has to go back.
Correct, Your Lordship.
All right. You say the main prayer in the present petition is that final assessment orders have been passed in respect of bills of entry by the petitioner without following the mandatory provisions of the Customs Act 1962, which required compliance with principles of natural justice and, importantly, for the authority to pass a reasoned order. Paragraph. When the present petition was heard on 14th March 2022, the order of this court. Stop. Pursuant to the above order, a counter affidavit has been filed on behalf of opposite parties 2 to 5, and a rejoinder has also been filed by the petitioner. To stop, this court has heard the submissions of Mr. Hardik Mode, learned counsel appearing for the petitioner, and Mr. Radhesham Chimanka, learned senior standing counsel for the department. Paragraph. Mr. Mode refers to one of the final assessment orders dated 19th September 2019 in respect of the reassessment of bill of entry number 475/8C/2016-17 dated 25th November 2016 per vessel MV Nandini. By the said communication, the Assistant Commissioner, Dhamra Customs Division, Dhamra, informed the petitioner that the aforementioned bill of entry had been, open quotation, assessed finally. And it was determined that there was a short payment of rupees 35,54,251 in respect of excess bunkers / stores consumed during the coastal voyage of the said vessel. Paragraph. Mr. Mode refers to Regulation 6(3) of the Customs finalization of provisional assessment regulations 2018, notified on 14th August 2018 under section 157 (D), read with section 18 and section 152 (Roman small 2), of the Customs Act 1962, which reads as under open quotation, bracket 3, where the final assessment is contrary to the provisional assessment, the proper officer shall pass a speaking order following principles of natural justice, unquote. Mr. Moth points out that not only was no hearing afforded to the petitioner prior to finalizing the assessment, but even the letter/order dated 19/9/2019 does not provide the reasons for determining the short payment of duty. Paragraph. Mr. Chimanka was unable to dispute the fact that there was no compliance with the aforementioned regulation. However, his only contention was that the petitioner has the remedy by way of an appeal. Full stop. As rightly pointed out with Mr. Moth, which is the decision of the Bombay High Court?
Your Worship, that is one compilation was submitted.
Yes. Zuari, is it? Who refers to the decision in Zuari Agrochemicals Limited versus Union of India, 2014 307 ELT 874, bracket Bombay, where the authority in question does not pass a reasoned order, then the aggrieved party cannot be relegated to an appellate, as that would serve no purpose without there being reasons provided in the order and appeal. Paragraph. Be that as it may, since there is obvious violation of the principles of natural justice and regulation 6 bracket 3 of the regulations, the court has no hesitation in setting aside the impugned letter/order dated 19/9/2019 and remanding the matter to the Assistant Commissioner, Dhamra Customs Division, Dhamra, for a fresh adjudication after giving the petitioner an opportunity of being heard and by passing a reasoned order. Full stop. The matter will now be listed before the Assistant Commissioner, Dhamra Customs Division, Dhamra, on 19th December 2022, on which date the authorized representative of the petitioner will be present, together with a downloaded copy of this order. Full stop. The Assistant Commissioner, Dhamra Customs Division, will then proceed in the matter and pass a final order of reassessment of the aforementioned bill of entry after hearing the petitioner by way of a reasoned order within a period of 3 months thereafter.
Only one request, Your Worship.
Yes.
This is one specimen copy of the bill of entry, but the total there are total 36 bill of entry, which is mentioned on page number 48. And my prayer is that was all the bill of entry assessment.
All right. You say the bill of entry dated 19/9/2019 and
on page number 48, Your Worship, Annexure 5, where we mentioned total 36 bill of entry and
as well as the 36 bills of entry set out in Annexure 5 series to the petition. All right. All right.
Your Worship.
Thank you.
Item number 89.
Beg your pardon, Your Lordships, I'm on VC.
Yes.
I'm for the petitioner.
Yes.
We have received a counter. We have sought for some instructions. We may be given some time for filing the rejoinder.
All right.
Your Lordship may kindly have a glance order dated 20th April 2022. The petitioner was directed to deposit 50% of the demanded amount. They have not filed any memo or affidavit showing that they have complied this order. If this order is not complied, they are not entitled to proceed with the detention.
Instruction to that, sir?
As per my instructions, sir, we have already deposited.
When?
Perhaps
Give
my
us a date.
learned senior is on his legs, so I do not have exactly.
No, we'll pass it over. You give us the exact date on which you deposit. Pass over.
Sir, 27th of June 2022.
Your Lordship may record it and.
All right. According to counsel for the petitioner, what's your name, sir?
Anish Mishra. So I do not have the power.
I know. Mr. Anish Mishra applies on behalf of Mr. Devashish Panda, learned counsel for the petitioner, and states that as per his instructions, in terms of this court on 20th April 2022, the petitioner has on
27th of June 2022.
27th of June 2022 complied with the requirement of depositing 50% of the demand. Full stop. A memo to that date of that date, enclosing the challans, has also been placed on record. Paragraph. Rejoinder be filed before the next date. Interim order to continue. List on 21st February 2023.
190.
Obliged.
Pass over.
That was 60.
Pass over.
Last two matter, item number 24.
None appears despite a passover. Dismissed.
Item number 28.
Appears despite a passover. Dismissed.
Item number 33.
33, and in this case, my lord, the order was passed for settlement of OTS. At that time, the management was not there and the OTS scheme was not there. That's why the review was filed. Now the management has come and OTS scheme.
Counsel, the petitioner states that due to subsequent developments, the petition has been rendered infructuous. It is disposed of as such.
Only that's my lord, direction to settle the on OTS. What are the order?
It's all right. It's only a review petition, sir. Not
that's why because of its pendency, that direction was given.
That's all right. It's already there. It's there. All right.
49.
Item 49 minutes. The directions have been complied with. I've given the photos in a pen drive. With your permission, may I share the photographs?
Where is that?
Well, it has been given in a pen drive. I've given it to the court.
Hole in the road has been filled up.
Yes, Millards. Millards, the last photograph, which is on 22nd, as of 22nd October. Millards, the last photo. Yes, Millards.
All right. Photographs have been placed on record, which reflect compliance with the directions issued by this court. Consequently, no further orders are required. Petition is disposed of.
Item number 50.
None appears despite a passover. Dismissed.
Item number 51.
You were saying something in this matter, Mr.
Yes.
Representation of something. None appears despite a passover. Dismissed.
Item number 52.
None appears despite a passover. Dismissed.
Pass number to item 61.
None appears despite a passover. Dismissed.
61 I am appearing, my lord.
All right.
Item number 62.
None appears despite a passover. Dismissed.
Item number 63.
May I please, Your Lordship?
Yes, please.
This is a matter regarding dispute pre-GST period, my lord. In this connection, the limit is given before, my lords, that the opposite party number 2 and 3, to whom I have already filed a representation, they have not considered my representation. So let me give you direction to opposite party number 2 and 3 to dispose my representation, my lord. That's the entire problem will solve.
Which is your representation, sir?
Annexure 12 and 13.
12.
Annexure 12 and 13, my lord.
All right. The petitioner's representations, bracket annexures 12 and 13, shall be examined by
opposite party number 2 and 3.
Opposite parties 2 and 3. And after giving the petitioner hearing, it shall be passed thereon, not later than. 9th January 2023 and communicated to the petitioner within a week thereafter. The court clarifies it has not expressed any view in the matter. If agreed by the said order, it will be open to the petitioner to seek appropriate remedies in accordance with it. The petition is disposed of.
Item 72. From 72.
None appears despite pass over. Dismissed for all prosecution.
Number 90.
None appears despite a pass over. Dismissed for all prosecution. Yes, yes.
Item number 48.
My lord, item 48. My lord, I would like to submit that the Rakesh Suna case is sub judice before the apex court, my lord. I have obtained the instruction with regard to that, and I have.
You mean this is this arising from this court's order?
This court's order, my
okay. That was, an SLP has been filed.
SLP has been filed. Till now, I have only received the diary number, my lord, which may be noted.
So if you want to await that, then we can.
My lord, in the other matter, in this Rakesh Suna matter, my lord, they have already filed the rejoinder, my lord, and it has not come up on record as per the noting, my lord. Day after tomorrow, that's all I pray for. For final hearing, my lord. I don't.
No, we don't have that time. But what is the anxiety here?
My
Because
lord,
we
the
have already
anxiety
passed an interim order.
Yes.
I mean, vacating the interim order.
Your Lordship may kindly have it. Your Lordship has vacated the interim order and the matter is now, and in the interim order, Your Lordship has exhaustively decided that this 2013 Act is not applicable to the petitioners who are admittedly the encroachers.
That is pending in an SLP.
Yes, they have preferred SLP
Correct.
and nothing.
Correct.
But my only anxiety is that despite this, because there are a lot of people, they are having small huts and shops rooms. Despite they are not allowing the district administration to and not coming forward for a negotiation because we are offering them a lucrative package.
Yeah, but that is something else that you have to deal with.
Because,
you can't pass an order
because
for
of the
that.
tendency of the writ petition. That is what my respectful submission is that Your Lordship may, if day after tomorrow she is asking for hearing, it can be posted to day after tomorrow. But only thing is that this pendency of this case is only standing on the way of vacating the person because they are claiming that the writ petition is pending. We will get this stay order from the Supreme Court. All these things
My lord, just a matter of 2 days, my lord. Just a matter of 1 day, my lord. It will be taken up for hearing the day after tomorrow. And in the other matter, my lord, 17004, we will file a rejoinder by tomorrow and may be taken up on record the day after.
No, 10th. We'll have it on 10th. You say it is stated that the specially petition filed by the petitioner in petition civil 13241 of 2022 against the order passed by this court on.
My lord, my lord, I don't have it on record because I am not the petitioner.
No, I think it was the 12th July.
Yes, my lord. Yes, my lord. That
2022 is stated to be is expected to be taken up by the Supreme Court very soon, is it?
She is not the lawyer for Rakesh Suna.
My lord, he has not been able to reach the court.
The lawyer for Rakesh Suna is absent.
I got instructions from him, my lord. He conveyed his instructions via telephone, my lord.
All right. All right. Accordingly, it is prayed that this court should defer the hearing of the present petitions, a request which is being opposed by Mr. Mohanty, learned additional government advocate.
Lordship, yes.
Nevertheless, deferring to the request of counsel of the petitioners, list on 10th November.
Highly obliged, my lord.
2020.
Highly obliged.
What about the weekly?
10th November for final hearing, Your Lordship.
For final hearing, my lord.
Lordship may indicate that 10th November for final hearing.
For final hearing. Why? We don't have a regular list? Why?
No.